Mr. Oxford.
My Lords, may it please you, in this matter I appear on behalf of the appellants, the Ahmed appellants, together with my learned friends Dr. Tim Sampson and Mr. Adam Riley. I also appear in Lifestyle's appeal together with Mr. Lawrence Sykes, KC, who's going to deal with the tax point, and Dr. Tim Sampson. My learned friends Thomas St. Quinton and Mr. Rory Brown appear for the Lifestyle parties on both parts of the appeals. My Lords, the timings we have agreed as follows: that I shall go on opening our appeal until 2:35 p.m. this afternoon. Mr. St. Quinton will then respond to our appeal and open his appeal until 1 p.m. tomorrow at lunchtime. I'll then reply until 3:40, and my learned friend Mr. St. Quinton will finish off with 20 minutes replying to my reply on his appeal. My Lords, there is, I hope you've received, we sent to the court a supplemental bundle on Friday. I did notice late last night, as I was piling my way through all the authorities, that needless to say there are one or two authorities that should be in the bundle, which we haven't got in the bundle, but which we can provide overnight. I myself don't need them, but you might want to look at them in due course. First is this: there is a case called My Kind of Town, Sol, which is a decision of Mr. Justice Slade at first instance. That is the case on which both of us rely. Unfortunately, the Court of Appeal's decision, which overturned Mr. Justice Slade on irrelevant points to this appeal, is there instead. So we're going to have to replace the Court of Appeal's decision with Mr. Justice Slade's decision. Secondly, for some reason, Colbeam and Palmer, which we rely on, doesn't seem to have made it into the appeal bundle, but I can make do without it for the moment, because it's referred to in another of the cases and sets out the principle I want to refer to.
So as far as My Kind of Town is concerned, will you have hard copies for us when you come to the appropriate point?
Yes, well, I myself wasn't going to refer. I can refer to the same principle in another case, because it's referred to. And likewise with Colbeam and Palmer, I can refer to it in another case. And then there's also another case called London Borough of Enfield, which we rely on in the Accounts of Profits case for a short dictum. But again, we can make available a hard copy, but it's only a short point we want to refer to it on. My Lords, on our appeal, you would have seen there are three main issues. First, did the Court of Appeal go wrong in law in holding that the Ahmeds were jointly and severally liable with Hornby Street? That's the first issue. Second, if the Court of Appeal was correct in its ruling on that point, did they nonetheless apply the wrong test for deciding whether the Ahmeds were liable to account for their profits, or at least did they fail to take into account relevant matters and take into account irrelevant ones? And then the third issue, which is really related closely to the second issue, is in any event, did the Court of Appeal go wrong in holding that the salaries paid to the Ahmeds could properly constitute profits, or at least if they could, did it go wrong in failing to award them an allowance for their labour against the relevant part of that salary? My Lords, what I propose to do first is deal first with the facts, briefly. Then I want to turn to our first ground, and then to our second, and then to our third. Before I do that, I should just take you to the Trademark Act itself, so you can see the relevant context, and that is in the primary authorities at E 1051, I believe. And one can pick it up in section 1, section 1.1. Trademark means any sign capable of being represented graphically, which is capable of distinguishing goods or services of one undertaking from those of other undertakings. It may consist of words, designs, letters, and so forth. Then registered trademarks. A registered trademark is a property right obtained by the registration of the trademark under this Act, and the proprietor of a registered trademark has the rights and remedies provided by this Act. And then turning to paragraph 5, relative grounds for refusal of registration, because you can register your trademarks. The trademark shall not be registered if it is identical with an earlier trademark, and the goods or services for which the trademark is applied for are identical with the goods or services for which the earlier mark is protected. And 2, a trademark shall not be registered if, because A, it is identical with an earlier trademark and is to be registered for goods or services similar to those for which the earlier trademark is protected, or B, it is similar to an earlier mark and is to be registered for goods or services identical with or similar to those which the earlier trademark is protected, there exists a likelihood of confusion. That's the crucial part. There exists a likelihood of confusion on the part of the public, which includes the likelihood of association with the earlier trademark. And then section 10, 1 and 2 and 3, these are the provisions under which Hornby Street, the company of which my clients were directors, were found liable in the first trial. 10.1, a person infringes a trademark if he uses in the course of trade a sign which is identical with trademark. Now that wasn't found, but section 10.2 was. A person infringes a registered trademark if he uses in the course of trade a sign where, because B is the relevant section, the sign is similar to the trademark and is used in relation to goods or services identical with or similar to those which the trademark is registered, there exists a likelihood of confusion on the part of the public, which includes likelihood of association.
And that likelihood of confusion is a sort of notional confusion, having regard to a use by the alleged infringer of the mark which is alleged to infringe in relation to any of the goods for which the mark is registered.
Yes, that's right, yes. And it's a likelihood of confusion. You don't have to bring evidence of, as it were, get lots of members of the public coming along and say, oh, I was very confused. It's a matter.
Well, sometimes you do, but you don't have to.
You don't have to, yes. And then section 10.3, a person infringes a registered mark if he uses in the course of trade in relation to goods or services a sign which is identical with or similar to, again, that's the relevant provision here, the trademark, where the trademark has a reputation in the United Kingdom and the use of the sign, being without due cause, takes unfair advantage of or is detrimental to the distinctive character or repute of the trademark. So there, and that we were found, or rather Hornby Street was found liable for under section 10.3, and again my clients were found jointly liable in relation to in the second trial. Over the page, 10.55, action for infringement. An infringement of a registered trademark is actionable by the proprietor of the trademark. 2, in an action for infringement, all such relief by way of damages, injunctions, accounts, or otherwise is available to him, as is available in respect of the infringement of any other property right.
Back to section 10, subsection 2. In the course of a trade, whose trade?
Good question, my lord. We say in the course of Hornby Street's trade. It is not enough to say, for instance, as I think the lifestyle parties now do, well, Mrs. Ahmed, or Miss Ahmed, herself was said to have been selling the goods. We say, on a proper construction, this applies to sales by people operating in the trade themselves. And that would therefore be, obviously applies to Hornby Street, but it wouldn't apply to employees or directors of Hornby Street who cause the sale, or indeed who may even be at the counter when the T-shirt is sold. We say that is not the intention of the Act, or indeed of the relevant European provision.
What was the authority for that proposition?
There's no authority either way. We do refer in our case to a couple of European authorities where they seem to treat the relevant person who could be liable for an infringement as, quote, an economic operator, as where they translate this notion into economic operator. I can't remember precisely where it's referred to in our case, but you'll see it in our case. But I haven't been able to find, nor perhaps pertinently Dr. Tim Sampson, who knows more about this area of the law, I haven't been able to find any authority which conclusively decides, or indeed even grapples with, the question, whose trade? But, my lord, can I just say on that, the word use, on the whole, just the word use, tends to suggest avail oneself of. I use my knife and fork, and so forth.
But use is defined, isn't it, in subsection 4?
As including, I think, my lord.
In particular, yes, that's true.
Yes. So, of course, what I say is, if there is a use by Hornby Street, then a sale by Hornby Street counts. But it's not, you have to bring yourself, if I can put it this way, within the normal use of the word use. And I say, on the facts of this case, and indeed by reference to company law principles, it cannot be said that an employee who's acting in the course of a company's trade is using the mark when that employee sells the infringing T-shirt or what have you.
Was there any finding below as to use by the directors, the Ahmeds individually?
No. I'll have to come to this. What the judge did find at one point, I will be coming to it, he did find at one point that when discussing what Miss Ahmed did, that she sold stock, infringing stock. But he later again goes on to say that it wasn't the case that it wasn't the case being put against her, that she was herself selling. I'll have to come to that. Okay. And the finding made by the judge is not, I should say in relation to Mr. Ahmed, there's no suggestion he was primarily liable as a seller. So the point arises in relation to Miss Ahmed, and in relation to Miss Ahmed, I simply say, well, what I've said before, that she's not herself using. And indeed, the judge doesn't appear to have found that. And perhaps most importantly of all, the judge did not find, as I read his judgment at first instance, that Miss Ahmed was, quote, primarily liable. What he finds, and I'll have to come to the judgment, is that she was jointly and severally liable with Hornby Street, which suggests, in other words, for causing Hornby Street to sell, as opposed to herself being the seller.
Certainly
so for Miss Ahmed to herself be using, and it would be necessary for her to be doing that in the course of a separate business, a separate trade?
I say it would be, if she was in the course of her own trade or as an independent contractor, but not qua employee. In other words, the employee, when you go to Marks and Spencer's, and let's say they are selling infringing stock or whatever, the employee, or indeed the people who've authorised the employee, cannot be said to be using the mark. The company undoubtedly is, but the individuals, I submit on a proper view, are not.
That's one point. You also submit, as I understand it, that trade means the person's trade and not another.
That's right, yes. Yeah. It doesn't say in the course of its trade or his or her, it just said in the course of trade, hence the ambiguity. I can see that. If it said in the course of his trade or her trade, that would be it. It doesn't say that.
No.
So the question is, well, what does it mean?
But as I understand it, that's not the way the case is put against you.
No, it wasn't.
The way the case is put against you is not that the individual persons working within the SME who may have themselves stamped the goods or sold them over the counter were individually infringing because they were carrying on trade on their own account.
No.
The way the case is put against you, as I understand it, is that there was here a common design between the Ahmeds, as between themselves presumably, and also with the company.
Yes, that's the case. And that's why I say, in any event, it doesn't really matter, because it's not put, the case is not put against us on the basis that Miss Ahmed herself was carrying on her own trade of selling this stock. Clearly not. There is still then the question of can she be said to be using the sign if, in the course of Hornby Street's trade, she causes the stock to be sold. And you have my answer on that.
So the common design would exclude the employee who actually hands over the goods at the counter.
Yes, I'll obviously be elaborating on quite what all these concepts mean when you consider companies. But, my Lord, I'm sorry, that's my answer to the question, use. I also say it doesn't matter in any event. As you will have seen, I say, even if, let us say, Miss Ahmed was, quote, using, and was therefore primarily liable, using the sign and therefore primarily liable for the infringement, I say still, that doesn't matter. I'll come to that in due course. So, my Lord, that's the Trademark Act. Can I just mention one or two points on the facts? As I read Lifestyle's case, they now suggest, or at least come close to suggesting, that in fact the Ahmeds were on constructive notice of likely infringement by the use of the Santa Monica Polo Club mark because of the likelihood of confusion. And I'll give you the references, paragraphs 128 at E245 and 139 at 246.
Yes, could you repeat those?
Yes, of course. 128 at page 245 and 139 at 246. Now, I just want to explain why I say that's not open to Lifestyle to raise this point. First, it was not alleged in the pleadings. Second, It was not put to the Ahmeds at trial, despite clear protestations of innocence by the Ahmeds in their witness statements, which were served, as it happens, about 6 months before trial and not replied to. Third, as I understand it, it wasn't alleged in the Court of Appeal, but in any event, the Court of Appeal did accept that it could not be said that the Ahmeds were on constructive notice, and the reference for that is at page 354, paragraph 50. So I respectfully submit the point just isn't open in any event. I do also...
Constructive notice and cross-examination, do you?
Sorry? You have to allege it somewhere. If someone says...
You're pleading, certainly.
Yes, but it wasn't... Yeah. But what I'll come to exactly what happened in this case to make good the point. Now, as far as the pleadings are concerned, my lords, you'll have seen we set this out in our case in some detail. The main points are the following. The claim against the Ahmeds was put on the basis that it should be inferred that it was they who caused Hornby Street to act as it did, because they were its directors and guiding minds, and they acted in common design with each other, I emphasise that, and with Hornby Street. That is reflected in the SFI at E, page 124, paragraphs 18.2, and also for the
124 paragraphs, what, sorry?
124, paragraph 18, sub 2,
Yep.
and then also the pleading, the relevant bit of the pleading, I don't propose to go through it all, is at paragraph 28 of the re-amended points of claim at E442.
Sorry, re-amended points of claim, paragraph?
E442, and in particular you have to read it together with paragraph 28G.
Which was the first paragraph, please?
So para 28 at E442. And then paragraph 28G at E443. And we deal with the point in some detail, perhaps too much, at E147, paragraph 9 to E149, paragraph 14. But the essence of it is, you were directors, it should be inferred you caused these infringements because of your position as such. Secondly, there was no allegation of bad faith or deliberate taking advantage of Lifestyle's marks that was pursued. There was an allegation that was introduced in before the first trial of free riding, but that was dropped. So it took no part in the...
What do you mean by no allegation of taking advantage of?
Well, I think...
I mean knowingly taking advantage?
Yes, I mean knowingly taking advantage of, yes. I think the actual words used were free riding. But that allegation was dropped, and so both the first trial and the second trial proceeded simply on the basis of strict liability. The third point I want to emphasise in relation to the pleadings is that Mr. Kashif Ahmed, who is found to be the ultimate guiding mind, put in a witness statement on the 3rd of May 2019. Now that is after the first trial, but before the second trial, essentially saying, I didn't act in bad faith, I acted on advice, I thought the OHIM decision in my favour justified me carrying on, I couldn't see anything wrong with it, and so forth. Now, I get to come to one or two extracts from that, but he put that witness statement in on the 3rd of May 2019, and it appears at E930.
E what, sorry?
930.
930.
Lifestyle, after that, applied to amend to add a new cause of action, which did allege knowledge or lack of reasonable care on the part of the Ahmeds. I'll come to that in a moment. But on the 12th of June 2019, Master Teverson refused permission to add that allegation to the points of claim for the second action. And you can see that I think page 5, I'd like to show you this, at 554 of the bundle. Paragraph 13. paragraph 13, near the foot of the page, you'll see 4 lines up from the foot of the page, 20C. This is the proposed amendment. 20C claims, for the same reasons, that the quantum defendants and each or either of them are jointly and severally liable with the third and 11th defendants. It is averred that the quantum defendants, and that includes the Ahmeds, knew or had reasonable grounds to know they were engaged jointly and severally with the third and or 11th defendants in an infringing activity and seek to recover as damages unfair profits under Article 13 of the Enforcement Directive. So a new cause of action, but relying upon a new set of facts. And then you can go on to see how Master Tedderson dealt with that at page 557, at paragraphs 26 to 27. Paragraph 26, you'll see 4 lines down. In relation to 20C, it's Mr. Hill, who's acting then for the Ahmeds. Mr. Hill submitted that first this would require evidence as to the quantum defendant's knowledge or grounds for not knowing about the infringements. He said this would raise new factual issues, and in any event, he submitted separately that a claim of this type comes within a claim for damages rather than one for profits, counter profits. He submitted that it would be wrong, in principle, to allow the account of profits to be mixed up, as it were, in part in an inquiry as to damages, and that would be these would be factored issues which relate to what are unfair profits. I was persuaded by those submissions, and I do not propose to allow the amendments to bring in Article 13 or of the Enforcement Directive. So the position then stands: the claimants, or rather Lifestyle, were not entitled, or were simply bringing a claim in strict liability. And I'd like to show you too how the claimants, or Lifestyle, put the matter in their skeleton for trial, which you see at 963 at page 53. This is Lifestyle's opening skeleton. And after setting out, the context is they've set out the test for common design in Fish and Sea Shepherd. 963, paragraph 53. Irrelevant factors. And this is answering the points taken in the defendant's defence. It's therefore clear, but in light of much of the defendant's evidence, is important to state expressly that the following matters are irrelevant and do not provide a defence to allegations of joint liability. There's no requirement that the defendant intended to commit a tort, no requirement that the defendant set out to copy a claimant's mark, no need to establish any dishonesty or improper motive, no need for the joint tortfeasor to have undertaken the acts that led to the infringement himself. So that's how the case is put against us. Now, my lords, you'll be familiar with the judge's judgment, so I don't propose to go in any great detail to that. I would just like to take you to 1 or 2 points in the facts, and it's probably helpful just to go to the chronology at 1034. And one can pick it up in 2006. So you can see, if I can put it this way, so you can see how things would have looked to the Ahmeds. 2006, at in page 1035, you'll see the third box down, KA, that's Mr. Kashif Ahmed, decides he wants to create a mid-market volume urban polo fashion brand, street and loud and proud, more than Ralph Lauren's was. And you see he gets the idea for the name from the Santa Barbara Polo Club and Racket Club. The judge accepted that. And the trademark or word search is done, and they don't reveal the existence of Lifestyle's marks. And then 13th of June 2006, the UK trademark for Santa Monica Polo Club is registered as from that date in Class 25. That's clothing, footwear, and so forth, in the name of Continental Shelf. D3 is Continental Shelf. They are a related company to Hornby Street, which is D11. So, in effect, you can treat them as the same. And then, going over the page at 1036, 9th of February, 2009, the first wholesale sales of the Santa Monica Polo Club brand take place. That is it's not said here, but it's E50820. That's the paragraph 20 of the first judgment. And then, in 2012, going over the page, 1037, 18th of September, you'll see the EU device mark for the figurative mark shown below is filed in the name of Continental Shelf. There's then an opposition by Lifestyle, and the Continental Shelf is represented by Mathis and Squire. So the application to register the EU mark for Santa Monica Polo Club takes place on the 18th of September, and it is opposed at that point. It's important to note, however, that no complaints at this point have been made by Lifestyle about the use of the Santa Monica Polo Club marks. They hadn't written at this point saying, what do you think you're doing, or anything like that. They just opposed the registration. And then...
They may not have known about any use of the mark.
They may, well, my lords, I think the evidence appears to have been that they did, but in any event, there hadn't been. It may not, from our point of view, it doesn't really matter whether they knew or not. There had not been any complaint received, but there is an opposition received. The first complaint, as such, comes in near the foot of the page on the 28th of March 2014. And that is when Lifestyle's trademark agents write to the Hornby Street complaining about the use of the logo itself on a pair of socks. My lords, it's important to note the logo appeared on its own without the Santa Monica Polo Club point, so just the logo. So the complaint is about the logo pure. And then there's correspondence you can see near the foot of the page, at the end of which Mr. Ahmed, on behalf of Hornby Street, essentially, on 2nd of July, you can see at 10:38, offers not to produce any further product, to which Lifestyle had objected. And the judge held that was a counteroffer and it wasn't accepted. And then on the 30th of September, the OHIM decision comes out. So the OHIM decision took a bit of time. And I do want to show you that because it was, in my submission, a resounding, as far as one would normally think, a resounding victory for the Ahmeds, or at least for Hornby Street, or Continental Shelf. I just want to show you one or two parts of that, and it begins at 920. Now, in saying this, I'm not seeking...
Does this matter to any of the points of law?
It matters because of the point that's now being taken against us, that my clients are on constructive notice, and indeed what was the state of mind, and indeed reasonable state of mind of my clients. Now, my principal point is, none of that's an issue. It can't be brought. But if it is to be an issue, I do want to show you just what the factual background was, and why it is, we say, it is simply not open to have this point reopened at this second stage. That's all. I mean, it's, in a sense, I'm meeting a case against me as opposed to making a case. But if I can just very briefly take you to the OHIM decision, so you can see the strength of it.
Page.
And sorry?
Page.
921.
Thank you.
Begins, I think, actually at 920, but the substance begins at 921. And you will see the decision, opposition, and that is Lifestyle's opposition, is rejected in its entirety, and then the reasons are given. Opponent filed an opposition against all the goods of community trademark application. The opposition is based on the following trademark registration. So you there see the three Beverly Hills registered marks. The opponent invoked Article 8(1)A and B. And my lord, I just mentioned this. Lifestyle was not at this point invoking, I think it's Article 5, I might be wrong about this, where you invoke opposition on the basis that you've got a substantial reputation which is going to be infringed. It's simply opposed on the basis of likelihood of confusion. There's no suggestion of substantial reputation at all. And then you'll see the nature of the goods on page 922, on which the opposition was based, and there are essentially three marks which Beverly Hills rely on in the first half of the page 922. I don't think I need to take you to that. But over the page, I should show you page 923. You'll see the signs and a comparison at 923 of the signs.
We're not going to be refiled refinding the facts. It's probably a bit of a waste of time.
Yeah. Sorry?
We're not going to be refinding the facts.
I agree. No.
It would be a bit of a waste of time. There's some rather weighty issues of law to deal with. And
Well, my Lord, I accept Your Lordship's point. I just want to make this point. It's set out in our case in any event. I just want to make this point that when you read this decision, it is a decision which is clearly, it comes down clearly in the Ahmed's favour. And the reason I say it's important is because Mr. Ahmed, in his witness statement, made the point in terms that he relied upon this decision for the company's decision to carry on. Perhaps I can simply cut it short by giving you the references for that, where he says this decision, as far as I was concerned, justified our continuing with the Santa Monica Polo Club brand, and that is at page 932, paragraph 11, 936, paragraph 29, 936, paragraphs 33 to 34, where he says he did this because he thought it was in the best interests of the company to do so, and 940, paragraphs 48 to 50. Now, my Lord, the only other point I want to make is this. When the further complaints, no further complaints were made until 2016, when those complaints were made, Hornby Street stopped using the 1-horse and 2-horse logo and instead used the 3-horse logo. Nothing else after that point. And the other point is this. At the trial, the first trial, there was no challenge to any of the Ahmed's evidence about how the Santa Monica Polo Club mark had come to be had been made about, and Lifestyle essentially advanced the case both at the first trial and the second trial. It just doesn't matter.
May I just ask this?
Yes.
You're showing us certain images here.
Yes.
The assertion of infringement, the allegation of infringement that was found established,
Yes.
was based upon which mark?
Essentially, the marks you've just seen. In other words, the Beverly Hills, what you've seen there is 3 Beverly Hills marks. And I think one of them it's got 5844, I can't remember the precise number, but the relevant mark in this case, which we were held to have infringed, I think, is the one at 5884. My Lord, I'd have to go back to it. It's not all 3, but just one of them.
It might be helpful at some point if
Yes.
you're inviting us to take this on board as some sort of defence to a case which
Yes.
hasn't yet been developed against you.
Yes.
To know just what it is that you in your submission was found to infringe and which marks were infringed in that way.
Well, my Lord, if I can just go back, and I can help you now, I think. If go back to page 921. These are the, 2/3 of the way down the page, are the relevant lifestyle marks.
Yeah.
It's the middle one. 5482484.
Thank you.
That is said to be the mark we infringed. The EU mark we infringed. Now, the judge deals with this in his judgment. The UK mark that we were also held to have infringed was almost identical. Identical, except I think the judge says it's a little bit less clear.
And,
So-
and could you show us, please, the symbols that were found to be confusingly similar?
You mean the Santa Monica symbols?
Yes.
Well, essentially, he finds at the end of his judgment, I think, if I can just go to his first judgment.
Can you give us the page?
If I may, my Lord, just find that.
Or come back to us at a convenient point.
I can find it because I've got it to hand.
Thank you.
Page 503 is where the judgment begins, and thank you, Mr. St. Quintin helpfully has reminded me, it's 534, where you have a list, if I can put it this way, or a table of the relevant marks.
Yeah.
And the judge, it's rather curious, that the case actually was brought against us only in relation to certain marks. That then, my clients then said, but there are lots more marks like that. So the judge said, right, well, they're all infringing. Nothing turns on that. But these are the marks, the Santa Monica marks, which the judge found to be infringing. I think the ones that were actually sued on, I think I'm right in saying, may have been the ones right at the beginning, but I'll have to double check that. My Lords, with that, I now turn, if I may, to my first ground of appeal. The Court of Appeal should have held that the companies were not liable, jointly and separately liable. Now, my basic position is this. No case in England and Wales has properly considered, after detailed argument from counsel, the question that is now before you. That is to say, what is the position of a de jure director, or indeed an employee acting on the instructions of the directors, who, acting with reasonable care in the proper discharge of his duties to the company, causes it to do an act which turns out to be a tort of strict liability. And in particular, what I say is this. No proper consideration of this point was given in the cases usually cited for the proposition that a director who causes a company to commit a tort of strict liability is liable along with the company, namely Raynham and Performing Rights Society. When one looks at those cases, the issue simply wasn't before their lordships. Secondly, the point has been considered in part, but not fully, in 3 other cases. The decision of the Privy Council in Huatat, Lord Justice Slade's decision in Spritebrand, and Lord Justice Chadwick's judgment in MCA and Charlie Records. It has been considered in those, but not fully, and certainly not on facts such as this.
The first of those again, please.
W-A-H-T-A-T.
Thank you.
I can't remember off the top of my head the name of the other party, but I'll be coming to it. That's the second point. So I accept it has been considered, but certainly not fully. Thirdly, the position, I say this, the position which the Court of Appeal has reached, namely, there is protection for directors and, it seems, shareholders, making decisions in their, quote, constitutional role, they are protected, but employees who then carry out those decisions are not protected, and that appears to be the consequence of the Court of Appeal's judgment in this case, I say offends common sense and cannot be right. Cannot be right. And indeed, one wonders, what is the point of the protection for the directors in making that decision if the employees who carry it out are not likewise protected? And, my lords, I think it's fair to say that my learned friend and I, if we agree on anything, do agree on this. It can't be that we've got this halfway stage that directors sitting in the boardroom are protected, or indeed directors coming outside the boardroom protected, but not those who carry out the acts which they have authorised on behalf of the company. That, in my submission, is a proposition which very difficult to see how any system of law could come up with, and I submit is manifestly wrong. So what I submit, at least on the face of it, is before you now, is a binary, I think what they call a binary question. That is to say, either my learned friend is right, and directors who cause, and can be fairly said to cause, the tort of strict liability, they are liable regardless of where they're sitting when they make the decision. That's one possibility. And therefore everyone else down the chain is liable too. Or, which is my position, is the directors acting properly in accordance with their duties are protected. Therefore, all those who act upon that decision which are made by the directors are likewise protected. Of course, always on the premise that the directors have acted properly and the execution of their duties and with reasonable care.
For my part, I wouldn't understand Mr. St. Quintin to accept that set of propositions at all. But
no, he certainly doesn't accept. He doesn't accept what I've just now said.
No, but that it's all or nothing in the way that you're putting to us.
Well, I don't know if he.
But you'll come to that. Maybe the easiest course is for you simply to develop your own case, and then.
My lord, you're quite right to pick me up. He doesn't accept my part of the case, but what he does say, is that the rule, the rule should not be that directors are protected, but no one else. He does not accept, as it were, that
special rule for directors. Nobody's advocating.
Yeah, no one's advocating for that. So, in one sense, I do say the question before you, and if I may say, I'm not going to try to again say anticipate my learned friend on this. The question for you is: am I right in saying that if directors who act properly in accordance with their duties, they are protected, and all those who act in accordance with those decisions or instructions are likewise protected? Am I right in saying that or wrong? That's the question. And at least I start with this proposition: it can't be right that the protection stops at the directors and doesn't go any further.
You could have a case, quite easily have a case, particularly in a larger company, where the directors are not involved at all, and all the relevant decisions are taken by executives who are not directors.
Yes.
The same issue would apply, wouldn't it?
Well, it would. If the executives were acting in accordance with their authority and in reasonable
Well, they've got a general authority.
Yes. Oh, well, yes.
But nothing, no particular authority relating to any particular type of goods. But they choose to manufacture and market what turn out to be infringing goods.
Well, that's right. I mean, one
Same
assumes...
point, wouldn't it?
Sorry?
It would be the same point.
It would be the same point, yes.
So this isn't a case that turns on directors' duties.
Well,
I mean, because it could equally well turn on employees' duties.
well, in this particular case, I submit it turns on directors' duties.
yeah.
But I can see that any employee acting in good faith in the within his authority and so on and so forth, all the usual things, I submit it shouldn't make any difference as such whether it is a director or an employee.
Right, so we needn't focus terribly on directors' duties. We needn't take up a lot of time by looking at the statutory provisions on directors' duties, because we might as well look at what the law requires of employees.
Well, the difficulty is, my lord, there is no particular authority on that.
Well, employees owe duties of loyalty and all the rest.
Oh, yes, well, exactly. Yes.
Competence and
Yes.
so on.
Yes.
But, I mean, you're not seeking to say that the law is different for employees who are acting on their own initiative but within their authority
No.
than it is for directors.
Exactly. But, my lord, I do submit it's helpful to look at the position of directors, because if the position of directors who give instructions, acting reasonably and carefully and so forth, if they are protected and those instructions are then acted upon, that, I submit, does give you a steer in answering your lordship's point about what is the position of, let's say, the senior executive employee who acts within a general authority.
Yes.
So I do submit one does have to look at the position of directors in order to arrive at what the right conclusion is for employees who have, in your positive circumstances, a general authority.
Well, the employee with a general authority, the company would be vicariously liable in such circumstances. The company hasn't done anything apart from acting by its employees.
Well, my lord, I would balk at the notion of vicarious liability. I would say the company is liable. So, in other words, the employee, because if it's vicarious liability, that implies that the employee himself is liable. My position is the employee is not liable because his act is to be taken to be the company's act. That is, in my submission, the fundamental point. There is no difference, so to speak, in the eye of the law between him and the company when he performs his duties properly to the company. Of course, if he does so negligently and so forth, that's a very different matter. But if he is simply doing what he must and acting within his authority and carefully, then in my submission, he is not liable. The company is. And, my lords, that, in a sense, is the crucial point for which I argue. There may be circumstances, in other words, where the company is liable, let us say, for the tort of strict liability, but the director who causes it, or the employee who causes it or acts upon it, is not. That, as we say, is the fundamental proposition.
Well,
yes.
Be careful. You're embracing a lot of different points there, and
Yes.
the employee who puts the goods on the lorry, or the employee who unpacks the goods, the employee who puts them into the store. Then they may be said not to be in any event carrying on any sort of trade on their own account.
Well, I agree with that.
Nor would it be said they're engaging in a common design with the company to carry on any activity. As I understand it, what is put against you here is a rather different case, which is that the Ahmeds conceived and set up this operation, which was then actually, as a matter of business management, put into effect through the company, and the company did all the acts which were necessary to constitute an infringement of itself, but in common design with these two particular individuals. And in that capacity, having acted in that capacity, they don't escape because they were directors of the company.
My lord, that's the case against me.
But so I'm just urging a little bit of caution in your description of the nature of the issue here as being effectively the same as to whether or not a shop girl or a shop lad is infringing when they hand over marked goods to a customer.
My lord, I accept that.
It's a quite different...
but the different considerations would apply to the shop girl and so forth. I agree with that. My lord, I would just, if I may, for the moment, just like to deal with the position of directors, because my clients were sued on the footing they were directors, and indeed senior executive employees, if you like, who caused all this to come about. Now, I just want to emphasise there is no issue on the causation point. We accept that. The issue is simply the mental element. Can they say that as we were acting in the execution of our duties owed to the company, our fiduciary duties as directors, and our duties of fidelity to the company, can they say that gets them off the hook? Yes or no? And we say it most certainly does. And I do want to go to the cases to explain that principle, if I may. I say one has to go back to first principles. I think I just wanted to make one, but I think I'd mentioned the point that the UK cases haven't really dealt with this proposition. That's Raynham Performing Rights, White Horse Distillery, Sprite Band, and Charlie Records. They haven't really grappled with it. The authorities that have come from Canada and Australia. They really have looked at this, especially in Australia. And on the whole, the view they have come down to is that directors acting in good faith and so forth in the execution of their duty are not liable, along with the company, for causing the company to commit an intellectual property tort of strict liability. That's the view they've come up with. And I submit they're right. My lord, my lord says one other point. I say if I'm right on the law as to what the legal test is, then the burden of proof is upon the claimant, or was upon Lifestyle in this case, to plead and prove fault and breach of duty and so forth on the part of my clients, given that they specifically sued them on the footing they were the directors who caused the infringements in question.
Well, they with respect, the way, as I understand it, the case is put against you is that these individuals caused these activities.
Yes.
And the fact they were directors doesn't affect that position.
That's right, yes. Absolutely.
You're laying the emphasis on the director aspect of it, but that is not, as I understand it, the way the case is put.
Well, my lord, I just want to say as a matter of burden of proof, I think there is an issue between us as to on whom is the burden of proof. As I understand it, what Lifestyle says is, well, if we wanted to run the point I'm now running, we should have put it forward in a defence. I say no, it was for them to plead and prove that we were acting outside our authority and without reasonable care. It's as simple as that. I will need to address you on that. There are some authorities on it. My lord, the point of principle. That is to say, a director performing, or any employee performing duties are not liable. I submit taking it from first principles, one arrives at the following. Save in special cases, the company carries on its own business and is not the agent either of the directors or the shareholders. And that's elementary, but that comes from Salomon at E 1789, and in particular 1798, it's Earl of Halsbury's speech, and in Raynham, Lord Parmore's speech at E 1718. Now, I emphasise that because it means that one traditional analysis for joint liability is not open on the facts of a case such as this. Namely, it cannot be said that the directors acting as principals were procuring the company to commit the torts, alleged torts, for their benefit and on their behalf. The only way in which liability can arise is if it can be said that the directors incurred liability while acting as agents of the company. And I do say this, that directors who make a decision to do something, acting properly in the discharge of their duties and without constructive notice of wrongdoing, are not liable to third parties for that decision if it turns out that the company's act done pursuant to it turns out to be a tort of strict liability by the company. The decision in those circumstances is not the director's decision, it is the company's. And likewise, I say an employee or even a director acting pursuant to such a decision without constructive notice of wrongdoing, likewise has no liability to any third party. His act is the company's act, not his own, and he too incurs no personal liability to the third party. And I rely on 3 points in principle for those points.
Maybe there's no resistance to that last point at any rate.
I don't know, my Lord. It's important because it is important to our analysis. My Lords, I say there are 3 reasons for this general principle. First, if a person acts with reasonable care and in accordance with the duties imposed by Parliament, or within the authority conferred by Parliament, he cannot, as a matter of elementary logic, be held liable to third parties for so acting. The parliamentary authority, pursuant to which he acts, protects both him and all those in the company acting properly under it. Second, and more generally, I do make this point. The obvious purpose of the Companies Act 2006 is to protect those who trade in good faith in accordance with the duties expressly or impliedly imposed by that Act. It undermines that purpose to say that directors or employees acting in accordance with their duties can nonetheless be personally liable in unlimited amounts for the consequences of their actions if it turns out that, contrary to what they reasonably expected, those actions infringe the rights of third parties.
You just repeat what you said. The purpose of the Companies Act is to
protect those who trade in good faith and in accordance with the duties expressly or impliedly imposed by the Act.
So it's the people trading with the company rather than the people in the company?
No, people in the company. It's to protect those in the company, all those in the company who are trading in accordance with the duties imposed upon them. I say that is the obvious.
Was there anything in the context of passing any of this legislation that would lead to that obvious purpose?
My Lords, there's only the general point, which is to encourage enterprise. That is the point of setting up companies with limited liability, is so that people are less frightened of losing everything because of the consequences of being personally liable for their actions when they trade.
That is businesses trading with the company.
Yes, but also if I want to trade, but if I want to be a trader, and this is obvious, it happens all the time, I will incorporate myself, so to speak. I will set up a company specifically with a view to limiting my liabilities, so that the shareholders are protected from liability for anything which happens to the company. Their liability will be limited to the agreed contribution for their shares.
Well, that is the point of incorporation, is to protect the shareholders.
It is to protect yes, I can see that.
The provisions of the Act dealing with directors are there to codify, to set out what the duties are that directors owe in the execution of their functions, and, to be fair, to whom they owe it, namely the company. Yes. But how far that affects tort liability is a rather different point.
It doesn't, my Lord, I agree it's a different point, certainly. But in my submission, it must follow that if I'm performing the duty imposed upon me by Parliament to the company.
But that's a curious one, because that would put directors into a special position. I mean, when I referred to employees, I was not necessarily referring to shop assistants.
No.
I was referring to executives who have significant authority in the structure of the particular company, but who are not themselves directors. And obviously larger companies, you've mentioned one, repeat it, they have many, many executives with wide discretionary managerial powers, but they're not directors. They don't have the benefit of, if that's the right word, the Companies Act provisions.
Well, they don't expressly have the benefit of the Companies Act provisions. My point is this. They do have the benefit of the general principle that if you're acting on behalf of a company in good faith and so forth, reasonable care, then their act is the act of the company.
Well, that I follow. As a proposition.
Why do companies in a special position? Suppose you work for a partnership.
Oh, my Lord.
You shouldn't be in any different position, should you?
Well, my Lord, I do.
Just because you're a company employee doesn't give you some special immunity.
Well, my lord, I say one does have to go back to the duties imposed upon directors. Because if I'm right, I understand your lordship's point. You might say, well, just forget all about directors. My answer to that is, you can't just forget all about the protection of directors.
Supposing it's a foreign company, so it's not governed by the director's duties in the Companies Act.
Well, my lord, I can't say that issue arises on this case.
I know, but I mean, it's a question of testing, isn't it?
Yes.
The proposition.
Well, it may then turn on what the duties owed. But there might, two questions might be. First of all, what are the duties owed by directors and employees to that foreign company in the first place? And then secondly, if they are different from those of English law, does that matter? But, my lords, I do respectfully submit that although one needs to test it by reference to other situations, the first question is, what about this situation? But, my lord, I think I do want to make good this point, if I may, just briefly, that if a director is performing the duty imposed upon him by Parliament when he makes a decision, how can it be at one and the same time that he is to be liable for the consequences of that decision?
Well, he's obviously liable if he's negligent, and you accept that.
Oh, I accept it.
And so, I mean, there's no exclusion of director's liability in relation to negligence.
Absolutely not. No, my whole point is, I fully accept, of course, directors are liable, both for fraudulent misstatements, negligence, and all sorts of things they're going to be liable for. The simple question in this case is, if you have properly performed your duties in accordance with the Companies Act.
But that applies to the actual tortfeasor themselves. They're not at fault in any way at all. So why should the directors be elevated in some way when the person who's primarily liable isn't?
Well, my lords, my answer to that is the person who is primarily liable is not liable where he has not been negligent. If he has simply done what he must and acted reasonably in doing so on behalf of the company, then his act is the act of the company. That is what it comes down to. And I do say it is important to look at the question.
But then why not apply that logic to negligence? The individual is acting on behalf of the company. His act has nothing to do with him. It's the company's act.
Well, my lord, if I may, respectfully, the answer to that would be an individual would be liable for negligence. The classic example would be the lorry driver and so forth. But a more sophisticated example is, I think, the case of UL, in which the director, senior employee, was responsible for badly laying out a boat, which resulted in an injury to the plaintiff. Now, the court held he had undertaken, or he came under a duty of care to the victim, and it was because he was under a duty of care to the victim that he was liable. But if he had not come under a duty of care to the victim, then he would not have been liable.
Well, transpose that into section 10.2 and 10.3. Those are the obligations which Parliament has imposed. Common law imposes a duty of care. These are obligations imposed by Parliament.
Well, those are strict obligations imposed on primary tortfeasors. That's undoubtedly the case. They don't actually refer to accessory liability at all. But, my lords, I fully accept that directors can be liable. The question is simply this. If they act properly in the execution of their duties, with reasonable care and honestly, and without notice, I say they have done what Parliament requires them to do in making that decision. And I do say it follows from that I'll come to the employee in a moment, it follows from that they cannot be at one and the same time liable to a third party for the consequence of that decision. They're entitled to say, I made this decision in accordance with the criteria set out by Parliament. I therefore cannot at one and the same time be liable for the consequences of that decision, but the company is.
I don't see why the fact you're performing your obligation to A means that you don't commit a tort towards B.
It doesn't necessarily follow from that, but in this case you're doing so under parliamentary authority.
That would make all the difference, wouldn't it, if the duties hadn't been enacted in statute and they just existed still at common law?
My lords, I say no. Far from it. Because the role of a director has always been a statutory role. And therefore, the law has always imposed certain duties on those acting in that statutory role. And therefore, I respectfully submit, it's perfectly, would always be perfectly open to the courts to hold, before the 2006 Act, that for the proposition that I'm now advancing. But I do say that now that Parliament has expressly put its imprimatur on these duties and set them out in clear terms, using the word must, you must do this, you must do that, then I respectfully submit that a director who complies with those duties cannot be liable for having done so. Take, for instance, this example. Let's say the idea is floated that perhaps we should make T-shirts with 2 cricket bats upside down. And the director says, and they think, well, this is a very good idea, it's going to help for various reasons the local community. This is an absolutely brilliant idea. And they do research into it, and they decide it's a very good thing to do. They have no idea, and reasonably, they have no idea they're going to be causing a trademark infringement. They then put this idea into practice, they give the relevant instructions, and the T-shirts with 2 cricket bats get into the market. Now, they, in my submission, would be entitled to say, but I acted in accordance with my duties imposed by Parliament when I came up with that decision. I didn't do anything wrong, and you're now telling me I'm liable for doing what I reasonably thought was in the company's best interests.
You're spending a lot of time on Proposition 2, and at the moment you're not getting much mileage, at least from some members of the court. I'd be interested in hearing more about your Proposition 1 and maybe Proposition 3. I don't know what that is yet.
Well, my Lord, Proposition 1, my Lord, just forgive me, that was directors who make I thought I was...
Before you got on to directors, you had a broader proposition, I think, about the nature of trademark infringement and liability. I didn't entirely... Or does it all depend on the director's point?
My Lord, it depends on the director's point. I don't say... Right. I mean, I accept that there can be accessory liability for trademark infringement. It's not actually spelt out in the Act, but the authorities clearly suggest or show that you can be liable as a secondary party for trademark infringement, albeit there's a statutory tort.
I thought you were developing a principle, though, that if somebody was acting in accordance with a authority and weren't committing a tort themselves, that they couldn't be liable for trademark infringement. Oh, well, I certainly do advance that proposition, yes. My Lord... well, I was hoping you were going to provide some support for that, because if it all turns on the Companies Act, then, at least in some members of the court, you're not making much progress. My Lords, can I just make my third proposition? When a director or employee acts in accordance with his duties as such, this is a separate point, he is acting as the company. And so there's no question of there being, quote, a joint enterprise or a common design between him and the company, because there is no relevant jointness or common design. And I do want to expand on that point. Now, my Lord, I accept, I've said these are the general principles. Can I just accept what some of the limits on it might be? I do not contend that this protection must extend to shadow directors or de facto directors, not necessarily, because, of course, a shadow director or de facto director may not have any right whatsoever to be acting as such. They may have been disqualified and so forth. Secondly, I accept this too. There may be statutes which expressly limit the protection given to a director or employee by providing, for instance, a specific statutory defence, which places the burden upon that employee or director of showing that he acted with reasonable care. And that was the case in Spritebrand, and that was a point that troubled Lord Justice Slade in that matter. Thirdly, I do not say that this applies to acts done by those who are not part of the company, for instance, subsidiaries.
I'm sorry, you're going to have to go slightly slower.
Yes, my Lord.
Your third proposition again, please.
I do not say that the proposition to which I contend applies to acts done by those who are not part of the company, for instance, subsidiaries or independent contractors. That doesn't arise in this appeal, but I say that such subsidiaries or independent contractors would properly be regarded as independent actors, and therefore there would be room for the doctrine of common design.
So the subsidiary or independent contractor could enter into a common design with the company to carry out a particular activity when all of the primary acts were carried out by the company itself.
Yes, I accept that, yes. And the independent contractor would be, on the face of it, liable along with the company. So the principle for which
It would be in the course of the company's trade.
Yes. It must be in the course of the company's trade, yes. But the principle for which I contend is that those within the company who act properly in the execution of their duties within the company are not a different entity from the company. They are to be treated as the company. And that is a principle which I submit one does find in other areas of the law. I emphasise, of course, I'm not saying this is the case where they have personally acted negligently. I'm simply on the point where they have acted properly and without notice. And that, I submit, is a difficult issue. And realistically, I do respectfully submit the solution which I contend makes more sense than the alternative solution, which comes to this. Every time a company commits a tort of strict liability, it would seem that there is an individual in that company who is himself going to be liable along with the company.
And what's wrong with that?
So everything, my lord, because I submit that deprives the company and those working for the company in good faith of the protection which I submit they should have as a matter of policy within the companies. My lord, that's what I say. I also say it would have very, very surprising results. This is not a point that's been tested, as far as I can see, in the cases.
My question whether or not that is necessarily so, that there will always be one person responsible. May it not be the case that there isn't one person responsible, because the decision to come up with a particular goods which are marked with the relevant allegedly infringing mark is something which is arrived at by different individuals within the company, but not acting in a way which could be said to be a common design between them or between them and the company?
Well, my lords, I can see that might be the case, but if I may respectfully say, the division of labour could be such that it would be impossible to identify one person or to say that there's really any common design. But, my lord, I submit that would be an unsatisfactory distinction, that where, for instance, as we have in this case, Mr. Ahmed obviously depends upon other people as well. It does, in my submission, seem strange that just because you take a leading role, let us say, in the manufacture of goods, rather than it's 3 or 4 of you who put your heads together, it does, in my submission, seem rather strange that if he is the one who takes the lead, he is liable, whereas if it's 3 or 4 of them, then they're all off the hook.
Well, sorry, that with respect is put in such a general way that it doesn't answer the point which I was putting to you.
Yes.
Of course, it may be that there are 2 individuals who decide between themselves that this particular goods should be put into production by the company.
Yes.
But it may be that coming up with a design and putting it on the market is not the sole decision of one person or even a group of people, such that one can say, well, actually, they are the 1, 2, or 3 people who were responsible for coming up with this T-shirt bearing this polo design.
Well, I can see, in other words, my lords, it still gets back to the point there lots of people have contributed to the decision.
Ultimately, there must be someone who bears responsibility, isn't there, who has the authority on behalf of the company to decide that the infringing product be marketed by the company.
Well, my lords, I would say
there may be a committee or something which is discussing it, and it may be that they share responsibility, or it may be that the senior manager on the committee has responsibility. But there will always be the company cannot take a decision save through human agents.
Yes.
And it might be one human agent, it might be more than one human agent, all depending on the circumstances. But your point would be that that on the basis of the Court of Appeal's decision in this case, whether it's one person, 3 people or 5 people, they will be liable as accessories if they are the people who have authorised the company to issue the infringing goods.
Yes.
That's your point.
Yes, yes. My Lord, I'm grateful for the clarification. My Lord, that is our point. Can I just deal briefly with the Companies Act point? I do. In our case, we refer at paragraph 50, page E, 160, to the purpose behind the incorporation of the director's duties in section 170 of the Companies Act onwards. And, my Lord, in particular, can I just ask you to look at section 172 of the Companies Act? I think it's at 1076 or thereabouts. Now, my Lord, I accept that the purpose of the incorporation of these provisions was to make it better known to directors, it appears to be the main purpose, to make it better known to them what these duties were. 1066, I'm told.
And 66.
1066.
Thank you.
Now, these are duties which are rather different, or not different, but they are modifications of the general common law duties. And I just want to emphasise something in the words. Duty to promote the success of the company. A director of a company must act in the way he considers, in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard to the following among other matters. A, the likely consequences of any decision in the long term. B, the interests of the company's employees. C, the need to foster business relationships with suppliers and customers. The impact of the company's operations on the community and the environment. The desirability of the company maintaining a high reputation, standards, and the need to act fairly as between members of the company. Now, my Lord, what I say is, supposing a director, as it were, he's got that in front of him, and he decides, well, I've got no doubt we ought to be making this particular design. This is what we should be doing. And he's got no notice that he's doing anything wrong.
Myself, I don't see why they should put him in any better position than anybody else who's acting entirely innocently, doing what they think is for the best in their business.
My Lord, my answer to that is because he's doing it because Parliament has expressly told him he's got to.
Yes, but the common law tells employees what they've got to, and I mean, employees could perfectly properly,
yes,
when they're wholly ignorant and reasonably ignorant of the existence of another mark, say, well, this is a good product, this is a good logo, we should issue it. And the question that this case raises, I would suggest, doesn't depend upon your clients being directors, but does depend upon them being the human agents of the companies in question. So I should have thought that the proposition you gave us a moment ago about when a director or employee acts and so on in accordance with duties, he's acting for the company and there's no common design, that's really the issue that is raised here.
It's the second way I put the case, and perhaps I'll go on to that. Although I'm getting a bit of a...
well, you've set it out in your written case, Mr. Knox. I mean, it's quite fully set out.
One never always hopes people change their mind, but not change their mind, but rethink. But I do submit that this is an important point. I take your point about employees, but I do say if there is this protection for directors, as I say, then it must follow. The scheme of the Act is it applies to all within the company as well. That is how I put it. That's the relevance of these provisions. And I do say Parliament has expressly now said these are your duties. That's that.
I couldn't conceive of Parliament having in mind this particular factual scenario when they were enacting.
That is no doubt true, right? I can't. There are lots and lots of papers produced to this, and I don't think I've seen anything like that. But that is probably true. That doesn't matter. If the words are clear, they're clear. And I say they're clear. Can I now come on to the other point, which is the common design point? And we deal with that at paragraphs 67 to 85 of our case. And what we say, in relation to cases, in relation to the slightly different category of case, which is where the directors cause a company to act in breach of contract. And the principle, I say, that emerges from those cases, and I'm going to take you to one which considers the others, the principle that emerges from those cases is that where a director or an employee or anyone acting on behalf of the company causes it to do an act, such as terminate someone's contract wrongfully, then
Such as?
to terminate another party's contract wrongfully, his act is seen not as his own act, but as the act of the company and as the act of the company alone. And my lords, if I can just take you to page 168 of our case, page 168 in the bundle.
Unfortunately, the bundle seems to have different numbering from our
Yes.
paper copies of the case. But
Yes. Anyway, this is your case, paragraph
76.
76. Yes, I'm saying the same problem.
O'Brien and Dawson.
Yes. Now,
Page 51 of the bundle.
my lord, I've got 168. 51.
Well, you're right, that in the big bundle it's 168, but in the core bundle...
Oh, I see, forgive me.
Yeah.
I think key bundle maybe, yes. Now there are two, there are, one thing I did notice when doing this case is how many cases seem to turn on theatrical matters, but it's... but anyway, in paragraph 76 I summarise what is said in O'Brien and Dawson. The defendant directors procured their company to terminate an agreement with the plaintiff, so as to enable them to eject him from certain theatres which he had previously been able to occupy under the contract. High Court upholds dismissal of his claim. But Mr. Justice Stark puts the point in relation to the claim against one of the directors responsible for this, Mr. Doyle. The acts of Doyle were the acts of the company, and not his personal acts which involved him in any liability to the plaintiff. Doyle was acting within the scope of his functions as a director of the company in procuring Dawson to terminate his employment with the company and to enter into an agreement with the company. It was an unlawful act of the company done through the director, Doyle. But Doyle is not involved otherwise than as a director. It was again the company's act. Now, my lord, I say the same logic would apply in relation to employees.
If Mr. Doyle was an employee, he shouldn't be liable either.
Sorry,
You said if Mr. Doyle was simply an employee, he shouldn't be liable either.
yes, exactly. Now, I would like to take you to the case which I next refer to at paragraph 77 in the authorities themselves. And this is the Court of Appeal's decision in Arthur Putra at 1892. At 1917, paragraph 63.
Just give me the page again, please.
Yes, 1892.
But the paragraph 63.
63.
1917.
1917, thank you. Yes, thank you.
This was a case in which one of the allegations was that the defendants had wrongfully procured the termination of the claimant's contract. I think it was to do with supply of various goods. The facts don't particularly matter, but paragraph 63, my lords forgive me, I'm just digging up myself. The Court of Appeal turns to the question of why it is that a director's personal liability for his company's contractual breaches. And they say, paragraph 63, first, conceptually, when a director acts in the exercise of his functions, as a director, and within the scope of his authority, he essentially acts in the company's capacity and not his own. He is effectively the company. And they then go on to go into more detail, referring to O'Brien and Dawson, about 7 or 8 lines down. As Jordan C.J. said in the Supreme Court in O'Brien and Dawson, was what I took you to as a High Court pronouncement, affirmed on appeal in the High Court, when an incorporated company acts through its agents, the agents, quote, are not in the position of outsiders or influencing the independent volition of a contracting party who is capable of exercising volition for himself. It would also be wrong to treat the director as conspiring with the company, and so forth. Now that, in my submission, is the principle. It doesn't make much sense to say that a director acting properly for the company is nonetheless acting in a common design with the company. It's like saying he's acting in a common design with himself. That is essentially the point. And then, my Lord, paragraph 64, I'm going to tread cautiously on paragraph 64, but I submit there is something in it. So the second, I'm not going to give up that easily. The second reason is one of policy, namely that of ensuring directors are not unduly deterred by fear of personal liability. And then the Court of Appeal goes on to deal with that point. And it's a point which one finds made in other cases, which essentially take the same attitude towards directors' liability. And then paragraph 65, well, perhaps I should just take you to the last bit of 64. Directors should not be coerced into exercising defensive commercial judgment motivated largely by anxiety over legal accountability and consequences. Bona fide entrepreneurs and honest commercial men should not fear that business failure entails legal liability. A company provides a vehicle for limited liability and facilitates the assumption and distribution of commercial risk. Undue legal interference will dampen, if not stifle, the appetite and so forth. Paragraph 65, on the basis of the 2 reasons above, our view is that the most appropriate elucidation of the side and but principle is that a director would ordinarily be immune from tortious liability for authorising or procuring his company's breach of contract, and so forth, unless, and this I emphasise, unless his decision is made in breach of any personal legal duties to the company. In our judgment, the principle operates as a requirement of liability. I obviously emphasise that, my lords, in relation to the burden of proof point, and not a defence. In other words, the onus is on the plaintiff to prove that the defendant director's acts were in breach of their personal duty to act in the best interest of the company, or it may be a breach of his contractual duty to the company to act within the scope of his authority, as granted by the company. We endorse to a large extent Mr. Justice Waller's interpretation of the principle in the Leon. And Mr. Justice Waller had said, in relation to a Said and Butt case, the immunity will be lost if the director commits a breach of personal, legal, or contractual duty. So forth. My Lord, that is the principle for which I contend.
Can you read that principle across to employees as well as directors?
Certainly. It would make no sense to give directors that protection but not employees. I put it as simply as that. And after all, directors, it depends what you regard as a director. A director will often, the premise of all this is the director is doing things. He's not just sitting in the boardroom. He's not just making a decision. He's putting that decision into effect. And that has to be done either through him or, of course, many directors are both directors and employees. So I submit it must apply, both, if it applies to protect directors, it must apply to direct employees as well, acting properly and so forth within the scope of their authority. They may have greater difficulty in showing they're acting in the scope of their authority if they decide to terminate someone's contract, but in principle, if that is their job, or in charge of human resources, as it were, then I say there's no reason at all why that shouldn't happen. And my lords, from recollection, that's in Said and Butt, Mr. Justice McCarty, I think, actually said this would apply to employees as well. The principle would apply to employees as well.
But the principle that you're putting to us, that an incorporated company acts through its agents, and the agents in those circumstances are not in the position of outsiders who are influencing the independent volition of the contracting party who's capable of exercising volition for himself, applies to directors, employees, or a combination.
Yes, my lord, my lord, I'm grateful. That is my point.
And that's really the heart of your point.
Yes, it's my point. It covers everyone acting properly within the company.
Yeah.
There has to be something that can be said to be joint. Now, in paragraph 66, I I don't know. I think I got to the quotation. I'm sorry, I've lost my thread a little. I got to the quotation halfway down 1918 about you will lose your protection if you act in breach of your duty to the company. The second line, such unlawful conduct may, I think this is citing from a textbook or an article, such unlawful conduct may include, for instance, a breach of the director's fiduciary duty. This may occur where he's acted to advance his own or another's interest rather than the best interest of the company, or where his conduct is akin to fraud. By insisting on proof of some independently unlawful conduct on the part of the director, this approach precludes any attempt to affix personal liability on the director, whose only wrong is having acted with malice or ill motive towards the claimant. Now that is being said in the context of procuring a breach of contract, and the Court of Appeal in this case go on to take a fairly hard line, namely, as long as you're acting within your duty to the company, that's it. The fact that you may also have been motivated in parallel, so to speak, by the fact you just don't like this chap you're sacking is irrelevant, as long as you're acting properly in accordance with your duty to the company.
Can it be said that you're acting in accordance with your duty to the company when you're inducing the company to commit the tort of breach of contract?
Well, this is what these cases, and indeed the entire line of cases, says is the case. There is one dissenting or doubting voice in, I think, Lord Justice Dillon, in one West Mercia. I can't remember the name of the case off the top of my head.
So, but is the law looking both ways? In relation to the company, it says, well, that's a tort. But in relation to a director, he says, well, he's acting in accordance with his duty to the company. That's excusable.
Well, in relation to the company, it's acting in breach of contract. In relation to the director who causes the breach of contract, the law, and I respectfully submit, is pretty well established. The law is he's entitled to do just that. And I'm also shareholders. I'm going to come to another decision which I definitely want to show you, of Lord Newburger's, again in Singapore, in relation to shareholders, which you have exactly the same proposition. If you're acting properly in the execution of your duties to the company, even though you know what the consequence of your action is.
But that was the bit I wasn't quite sure of. I mean, my understanding is that it is well established that a director or employee is not liable in tort for inducing a breach of contract by the company, of a contract with the company.
Yes.
But is that right where the director knows that it's a breach of contract?
Yes. Oh, yes, that is the point.
Yeah. Well, because there are many cases, obviously, where contracting parties act in breach of contract without intending to, but it's held that they were in breach of contract. But where there is a deliberate breach of contract, it applies also, does it?
Yes.
Yes.
Well, I don't think you can induce a breach of contract without knowing, can you?
I see.
Yes, I think in one sense it's built into the tort.
Yes.
Yes.
But it is very much, and this is I'm only showing you certain of the cases, but it is very much isolate established.
And you say, I mean, that's obviously, inducing a breach of contract is an independent tort. It's not a question of being an accessory to a tort. No, but you're saying that the principles that underpin the policy applicable to the tort of inducing a breach of contract should be read across and applied in a case such as this of accessory liability.
They should be read across and applied because the underlying principle is if you are acting properly in the execution of your duty to the company, you are the company. There is no jointness in what's going on. That is the principle. My Lord, just saying for a moment on Arthur Putra, 1919, the Singapore Court of Appeal says this. Second, it is desirable that the answer...
Sorry, is it paragraph?
69.
Thank you very much.
Second, it is desirable that the answer to the question of whether a director is acting in a manner that ought to absolve him from personal liability is consistent with whether he's acted in breach of his duties to the company. The alignment, I know my lords aren't so keen on this point, but this is what the Court of Appeal in Singapore has said. The alignment of immunity from personal liability with directors' personal liabilities to the company reinforces the view that where a director is acting within such confines, his acts ought properly to be regarded as those of the company and not himself. Well, my lord, that is the position I adopt. That is the alternative way of putting the case, and that is the significance of the director's duties in the Act. But where a director has stepped outside of his authority or has otherwise breached his duties to the company in directing the company's breach breach, he ceases to act in the company's best interests and steps outside as a third party capable of conspiring or otherwise dealing with the company. In so doing, his act becomes his own, a phrase which one sees in other cases, as does any consequent tort. He is no longer entitled to the protection on the basis that he acted as the company and should be treated as a stranger. So that is the principle, and in accordance with this principle, the Court of Appeal in Singapore allowed the appeal essentially by the director, because all that had been said was the director had caused the breach of this contract, knowing that that was the case, to which the Court of Appeal said, well, so what? Now, my lords, importantly, and I say somewhat presciently, at 1922, the Court of Appeal goes on to consider this point: a director's liability for the company's torts. And you can see, they say, I'm not going to read all this paragraph out, but the Said and Butt principle, which protects the director from tortious liability for his company's breach of contract, appears at first glance to be at variance with the director's personal liability for other torts committed by the company that the director had authorised or procured by the director. In virtually every other tort, trespass, intimidation, and so forth, the director is liable for any tort that's personally directed, authorised, or procured by him. And they go on to say what Mr. Justice McCarty has said in Said and Butt. And they go on to refer to various authorities which have said, well, it's established that directors can be liable for causing the company to commit a tort. That's all fair and good. I don't have a general problem with that as a general proposition, save on the type of facts of this case. They then go on at 1923 in paragraph 75. Is there a legitimate justification to permit immunity for directors in relation to their company's breach of contract, but not for other torts? This has frequently been acknowledged by the courts and academics to be anomalous, and was the reason why Lord Justice Dillon, in the English Court of Appeal, had grave reservations about the Said and Butt principle in the Welsh Development Agency case. That's the case I was referring to. We earlier expressed there are two reasons for the Said and Butt principle, one conceptual, the other based on policy. If a director acting in the exercise of his duties without breaching his personal legal duties to the company acts as the company and thus cannot be taken to have committed an independent act for which he's personally liable, it's uncertain why the same could not be said of directors who have in the same capacity authorised the company to commit a different tort. If the justification of Said and Butt is based on policy in terms of preventing over-deterrence, it is uncertain why a director may not also legitimately consider that it's in the best interest of the company to commit a tort, such as trespass or intellectual property infringement, in the best interest of the company. Now, I pause there for a minute. They're talking about a conscious, deliberate breach, but we're not in that territory at all. I'm on the much more modest, if I may say, proposition that if you don't know that you're causing a tort, then you shouldn't be held liable. Then, in paragraph 76, they go on, I don't propose to read all this out, they go on to propose one of the distinctions between causing a breach of contract on the one hand and causing a tort of strict liability on the other, and namely, if A contracts with company B, then A knows that company B is managed by its directors and its employees and such, and therefore he implicitly takes the risk that company B will terminate the contract by the acts of its directors and employees. In other words, you sign up to that risk, inevitably, when you enter into a contract. Whereas in the case of a tort, the owner of the relevant property, whether it's a piece of land or intellectual property, he hasn't signed up to anything in advance. And so that's one potential distinction. And they say, well, that's one way of explaining why the rule is limited to causing a breach of contract. That's one possible approach. You say that you restrict it. The other, and they say at paragraph 78, the second possible response of the courts is to reconsider the position of a director's liability for other torts and hold that a director is likewise protected from personal liability if he has acted properly in the discharge of his duty to the company. In an article, my lords, which we refer to in our case, the author suggests a two-stage test in determining a director's liability for such torts. First, the director must have been involved in a material way in the company's tortious act. Second, the liability upon directors should only be imposed where the directors were not acting properly in the discharge of their duties to the company. And then they set out what his conclusion is. In particular, the sentence beginning in their management. In their management of a company, directors are required to act honestly in what they believe is in the best interest of the company, and they should be allowed to do so without any fear that if they inadvertently cause the company to commit a tortious act through the act of another, they will be personally liable. And my lord, that is the principle in a nutshell which I contend.
Sorry, have you covered the sentence in paragraph 79, where the director authorises or directs the tort on behalf of the company? Although his involvement may be materially different, it is understandable that the victim may view him as equally culpable.
Oh, yes. Oh, my lord, they go on to say, that's not the end of it. I mean, my proposition, the proposition which I contend is 78, they then themselves go on to say, but one can understand that this is not an easy question. They don't decide the point, far from it. And they do, as you say, paragraph 79, the basic tenet of tort law is, and when a director personally participates in the tort, such as personally trespassing on another, that is not this case in my submission. There's no tort committed by there's no direct tort committed by the Ahmeds. What is said against them is they procured the company to commit the tort, which is slightly different. And I do submit that there could well be an important distinction there. And this is a point, actually, the distinction which the Court of Appeal, I'll show you in a moment, goes on to acknowledge. But I do, here they're talking about the victim. From his point of view, what difference does it make to me? You infringe my property. But it says, when a director personally participates in the tort, such as personally trespassing on another's property, even though authorised by the company, there may well be a good reason to hold him personally liable as a tortfeasor. Where the director authorises or directs the tort on behalf of the company, although his involvement may be materially different, it is understandable that the victim may view him as equally culpable. As this issue is not directly material to the present appeal, we do not express a concluded view, but raise these observations for future consideration when this issue becomes central to the outcome. Suffice to say that there are compelling arguments in support of both views. So, my lords, as it were, over to you. But this, I should say, my lord, this case considers in considerable detail, if you go back, I think, to paragraph 51 of 1911, it does consider all the cases in this area in considerable detail. And what I say is that notwithstanding Lord Justice Dillon's reservations, this tort of causing a company, or rather the principle that you are not liable for causing a company, qua director, for breaching a contract, is well established, unless it can be said you've acted in breach of your duty to the company. That is a well-established principle. I also say it is well established in other areas that the person who's acting on behalf of the company properly is to be regarded as the company. And, my lord, perhaps the best place to look at that is in the case of Trevor Ivory, where that is said both by Mr. Justice Cook, or later Lord Cook, and by Mr. Justice Hardy Boys. And this, my lords, is at 5071. Page 5071.
Thank you.
I'm having difficulty at the moment.
Yes.
Trevor Ivory.
I'm sorry, I'm just going to have to get my computer in operation.
This looks very similar to the natural health care, or whatever it is, case
It is
in
indeed.
the House of Lords.
Yes. It's the paragraphs, I won't read them out, paragraphs beginning from line 4 to line 30. That's the first reference I want to go to.
The fact that your act is attributed to the company doesn't mean it isn't your act, though.
My submission, it is. It does mean just that. That as long as...
I mean, it doesn't prove itself, that proposition.
I agree.
Does it? Either it can still be treated as your act or not, but it doesn't answer the question. Just to say it's that the act is attributed to the company.
Well, but, my lords, in one sense, these authorities show that if you do act properly within your duties to the company, then it is to be taken as the Companies Act, and only the Companies Act. You might say, why should that be? You have my answer to that. It's because you're doing what you're required to do by the company. You're acting in the execution of your duties to the company. My lords, that is the principle for which I contend. My lords, I draw attention to this passage and also at page 5076.
Sorry, could you just please make clear to me, 5071, which particular passage do you...
It's the reference to, I think, Tesco and Truss, which one sees at 5071.
Yeah, thank you.
That a person may be identified with a corporation so as to be in its embodiment or directing mind and will not merely a servant, representative, agent or delegate. And then the application of that doctrine. More to the point, my lords, I'd like to go to the judgment of Mr. Justice Hardy Boys at 5076.
He does say at the end of that paragraph, if a person is identified with a company vis-à-vis third parties, it is reasonable that prima facie the company should be the only party liable. But I don't know whether he goes on to discuss what the qualifications to that might be.
I don't think he does.
No, okay.
5076, the judgment of Mr. Justice Hardy Boys. At line 40, I think. Sorry. Yes, if I can just ask you to read from line 40 onwards, down to 5077. This was a negligent advice case, I should say. It's really to the foot of 5077. Or 5078, in fact, down to 20.
Sorry, so you want us to read to where?
Sorry, to 507, I believe it's written near, to 5078, line 20. Now, this is in relation to the imposition of a duty of care, but what Mr. Justice Hardy Boys is accepting is this notion of the identification of a director or an employee with the company, where he's acting properly in the execution of his duties to it.
That seems to give people who are the directing mind of the company a greater protection than people who are just agents acting at a lower level.
Well, I agree. That
seems completely counterintuitive.
No, that's obviously wrong. My point is it applies to everyone. Clearly it can't just apply to the, as it were, the director sitting in the boardroom, but no one else. That doesn't make any sense at all. My lord, the other case, which is not a director's liability case, but it is the other Singapore case, which I would like to show you, is the case of Boomi, which I think one sees at 1931. Now, this was a case where the parent company had terminated the contract of employment between the subsidiary and the claimant, or counterclaimant, I think, as it happens in that case. And it's another judgment of the Singapore Court of Appeal, and it was given by Lord Neuberger. And what I particularly want to take you to at the moment, you can just see from the headnote, which is succinct, what the problem in the case was. Halfway down 1932, Totsi, that's the claimant, is about the third para down. Totsi commenced proceedings against BAOHL for breach of its right of first refusal and against BAB, that's the parent, in the tort of inducing boomies, I'll call them breach. The Court of Appeal below ruled in favour of the claimant, basically against the parent company. The principle was then dealt with at page 1944 in the judgment of Lord Neuberger. Third issue, is BAB, is the parent, liable for inducing breach of contract?
1944?
1944.
Yep.
And you can see what the argument was, just in paragraph 39. That's what the court below had held was the relevant issue. Yes. But you can go, if I may, to paragraph 42 of page 1945. Or perhaps I should take it 41 on 1945. The last 5 lines. The issues. Those issues are whether those individuals were acting for the subsidiary and or the parent, and if they were acting for the parent, B, this is the relevant issue, whether the circumstances are such that the parent can properly be held liable for inducing its subsidiary breach of contract. And then Lord Neuberger continues, as to the second of those issues, the question whether a person who exercises control over a company which has breached its contractual obligations can be liable for inducing that breach has been considered in several cases, but normally in the context of the director of the company rather than the shareholder who owns a controlling interest in it. Both types of cases are important that tort law should not be invoked to blur the principle that a company is a separate legal personality. However, given that a director is an agent of the company, whereas a shareholder is not, it may be dangerous when considering the question in a case such as this involving the shareholder who owns all the shares in the company to rely on cases concerning the position of directors, such as Side and Butt and so forth. And then Lord Neuberger continues. You start in paragraph 43, he refers to the Salomon principle. And then paragraph 45. In our view, the owner of, or indeed any shareholder in, a company cannot be held liable for inducing a breach of contract by the company if the actions said to give rise to its liability merely involve the owner or shareholder in the company pursuing in good faith its own interest in its capacity as owner of or shareholder in that company. If the sole or majority shareholder in the company formed the view that the company would be better off, shares worth more, if the company breached a contract and summoned a shareholders' meeting or persuaded the directors to give effect to that view, it would seem wrong that the injured party should be able to proceed against the shareholder for inducing or procuring a breach. Such a result is essentially dictated by the rationale behind the decision in Salomon. As if it were otherwise, a shareholder would effectively have to choose between sacrificing his right of pursuing his self-interest bona fide as a shareholder or finding himself liable for the company's breach. Such an outcome could lead to practical difficulties. And then over the page, at paragraph 48, Lord Neuberger concludes, it follows from the above discussion that BAB, the parent, could properly be made liable for the subsidiary's breach of Totsi's contract only if A, BAB had, as a matter of fact, induced BAHL to breach the contract, and B, in inducing the breach, BAB had acted in a way other than in good faith in pursuing its own interest as the owner. Now, the reason I say this is significant is because this is being dealt with from first principles. And the first principle that Lord Neuberger is advocating is that shareholders are entitled to pursue their own interests as long as they're acting in good faith within the role assigned to them as shareholders. And it, in my submission, reinforces, I say, the basic point that anyone within a company acting in good faith within his duty, director, employer, or what have you, as long as they're pursuing the company's objectives, should not be held liable. There's no proper basis for holding them liable.
liable as an accessory.
As an accessory, yes. And I say that is the proper principle, and that principle should apply in a case such as this. And I put it this way, why shouldn't it? Especially given this contrast. The directors or employees who are consciously causing a breach of contract know they're bringing about a breach of contract. It seems odd that they should have that protection on the one hand, but the innocent director or innocent employee of a limited liability company does not have any protection at all when he is pursuing the company's interests in good faith, and all the same things could be said about him. And indeed, the logic in these cases, the breach of contract, the contract cases, if I call them that, about the identity between the director or employee and the company should apply equally. There's no reason why it shouldn't apply equally in the case of a company. My Lords, I am conscious of the time. My next point is this. It's largely set out in our case, but I do say the English authorities do not really consider this question head on. And, my Lords, the first is Raynham, and perhaps I can deal for the moment in summary form without taking you to these judgments, except Charlie Records I will have to. In Raynham's case...
What's the page number, please?
I think it's around 17... It was around the 1700s, forgive me, my Lord, I don't seem to have that reference.
I'll try this.
1696. 1696. Now, in Raynham's case, the problem was that premises were used for making explosives at the beginning of the First World War, and then a huge explosion occurred when something called dinitrophenol, or DMP, was stored next to or close to nitrate of soda, with the result that a fire broke out. When a fire broke out, there was a terrific explosion. You get that from Lord Buckmaster's speech at 1702, last paragraph. A claim was then brought under the Rylance and Fletcher principle. And the two main questions arose. The first was, had the directors of the company, who had originally taken up occupation of the premises, had they managed to divest themselves of occupation so as to themselves be personally liable under Rylance and Fletcher? That was one issue. And the House of Lords held, yes, that was the basis of liability. The other issue before the courts was if the directors had divested themselves properly of occupation, such that the company which they managed was in occupation instead, were they nonetheless liable on the footing that they were the governing directors of the company who oversaw the inevitably dangerous operations on the site. Now, the Court of Appeal held by a majority that they were liable, whichever way one looked at it. Lord Sterndale and Lord Justice Atkin essentially said the directors brought the dangerous material onto the premises, and that was it. And Lord Justice Atkin said, what do you expect if you bring a dangerous tiger onto the premises, and things like that. Lord Justice Younger took a different view, and he held the company was in occupation, and the directors therefore were not liable as governing directors. Now, it's important to note this, and I just give you the reference. In the House of Lords, the argument by the directors was that they were not liable, A, because they weren't in occupation, and B, because merely being a governing director was not sufficient to impose liability. The point, however, that did not arise, because it didn't arise on the facts, that didn't arise was this. Supposing the director had put the dinitrophenol, the DMP, close to the nitrate soda, but in all innocence, would he have been liable then? Now, that point just wasn't discussed. It didn't arise on the facts of the case. But what the House of Lords did hold was that if the directors had given up possession such that the company alone was in possession, then they would not have been liable under the principle of Rylance and Fletcher, even though they, of course, caused the company to bring all the dangerous stuff onto the premises. So that was essentially what the issue was. And the passage which is often relied on for the principle that directors are liable for causing a tort of the company is at 1706 to 1707. Perhaps I should take you to that, because it is probably the fons et origo of the doctrine which we're now considering. Now, my lords, you can see the context of this. Perhaps one starts at 1706. Can I ask you to read yourselves the passage beginning, "But in truth the Companies Acts expressly contemplate," just down there, going over the page to 1707, the end of the second paragraph. This is really where we say the trouble begins.
Where does the passage begin on 1706?
1706, if you can take it from "But in truth," about a little bit more than halfway down the page. "But in truth the Companies Acts expressly contemplate that people may substitute liability."
Yes, thank you.
Now, I say one has to look at this carefully in context. All that Lord Buckmaster is addressing is certain possibilities which had arisen on the facts of the case. The first was, if you go to 1707, if a company is formed for the express purpose of doing a wrongful act. Now, that goes back to Lord Justice Scrutton's finding, was that Mr. Feldman and Mr. Partridge, the directors, had deliberately set up the company with a view to the company taking all the risk of this operation. And I submit that all this is saying is if a company is formed for the express purpose of doing a wrongful act, in other words, I know that we're going to do something wrong, but I decide to incorporate myself, then you can't get out of it like that. That's all that is saying. And then the next part, or if when formed those in control expressly direct that a wrongful thing be done, the individuals as well as the company are responsible for the consequences. But there is no evidence to establish liability under these heads. Now, the second part of that, or if when formed those in control expressly direct that a wrongful thing be done, has been taken to mean whether they knew it was wrong or not, and however careful they were. And that, I submit, is obviously, well, I say obviously not, but you can't read that into what Lord Buckmaster was saying. And even if you could, he was going well outside any submissions that had been made to him. It just wasn't an issue in the case. The issue was not, yes, I did put the DNP close to the nitrate of soda, but I did so in good faith and innocently. That just wasn't part of the case at all. And what I say is rather more significant about this case is that even though directors obviously did cause the company to do something dangerous, they were not held to be liable. And they caused it, in other words, to store dangerous material on the land, and there's no doubt that's what they knew. Now, my lords, I'm conscious of the time. I don't know if now is a good time. Sorry.
I think I'm
told it's just gone 1 o'clock.
Mr. Knox, we'll resume at 2 o'clock, please.
Right.
Very much.